This is AdTech God, and this is French 101. Welcome to class. The correct pronunciation is can, like a can of soup, not like cans of soup. Now that you've graduated, I'm here to tell you about the AdTech God Crashes Adweek House event happening on June 16th at 8:30 p.m. It's going to be fun, 80s style, and takes place in an absolutely stunning hotel called The Majestic. It's right on the Croisette. If you'd like to attend, go to adtechgodevents.com and register now. Invite your friends at agencies, brands, ad tech, media, publishers, even your neighbor if he happens to be going there with you. Just kidding. But we'd love to see you there. Everyone is welcome, and we're really looking forward to this event. See you at Cannes.
This podcast is brought to you by AudioHook, the leading independent audio DSP. AudioHook has direct publisher integrations into all major podcast and streaming radio platforms, providing 40% more inventory than what could be accessed in omnichannel DSPs. What's more, AudioBook has full transcripts on more than 90% of all podcast inventory, enabling advanced contextual targeting and brand suitability. AudioHook is so confident that in addition to CPM buys, they offer the industry's only pay-for-performance option where brands can scale audio and podcasting with peace of mind knowing they are only paying for outcomes. Visit audiohook.com to learn more. That's audiohook.com.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust and other regulations on the global advertising economy. If you are new to the Monopoly Report, you can subscribe to our weekly newsletter at monopoly-report.com, and you can check out all of the Monopoly Report podcasts at monopolyreportpod.com. I'm Alan Chapell. This week, my guest is Jonathan Kanter. Jonathan is the former Assistant Attorney General for the Antitrust Division of the Department of Justice and was effectively leading the DOJ antitrust efforts against Google. He is now a contributor on CNBC. If you want to know more about Jonathan's background, there's a great podcast that the Capitol Report did a couple of months ago. You should check it out. In my view, Jonathan, along with Lina Khan, deserve a lot of credit for his role in reinvigorating antitrust enforcement in the U.S. While this podcast is mostly focused on the digital media marketplace, I want to drive home that Jonathan's impact has been significantly broader, including bringing cases against Apple, Live Nation Ticketmaster, and challenging the merger between Spirit Airlines and JetBlue. This is going to be a two-part interview. In part one, we will discuss three specific issues. First, we talk more generally about the DOJ's approach during the Kanter era and how that compares to not only the previous 50 years of antitrust enforcement, but also how it compares to the current era under Gail Slater. Second, we talk generally about how both the DOJ and Google have approached the proposed remedies in these cases. And then third, I ask a number of questions specific to the Google search antitrust case. And yes, that'll include a number of questions about Chrome divestment. One more note before we get started. And I encountered a similar thing a few weeks ago when I interviewed Mark Hamer, who is currently at DOJ under Gail Slater, working on the Google ad tech case. Jonathan Kanter is not going to tip his hand and reveal internal deliberations while he was at the DOJ. So in my view, in a number of places, you need to read between the lines a bit to understand Jonathan's answers. But it was a tremendous honor to have this opportunity, so let's get to it. Hey, Jonathan, thanks for coming on the pod. How are you?
I'm great. It's good to be with you.
Well, thanks. So I thought I'd start with a really, really tough question. Piano or guitar? What's your preferred instrument?
Ooh, better piano, but I prefer playing guitar.
Ah, interesting. I grew up playing the piano. The closest I got to guitar was the ukulele. And I lived in Brooklyn, and I don't know if you know this being part of the government for a while, but you were legally required to play the ukulele if you lived in Brooklyn from about 2008 to 2011.
I'm fully aware. So I grew up playing piano and keyboards, but always wanted to be a guitarist, like most keyboardists. And so when I was in my 20s, I decided to take the plunge, bought a guitar, and then bought another guitar, and a few more guitars later, and a nice size collection. And it's a labor of love and a passion, and I don't claim to be any good at it, but I love it, and it's a lot of fun.
Yeah, Yeah, it sure is. With your permission, I want to start with some more general questions about antitrust enforcement in the U.S., and then maybe narrow things a bit to focus on some of the DOJ cases against Google, because that's really where my audience is going to be particularly interested. The first question is, as we moved from the Biden administration to the Trump administration, some of us were concerned that there might be a philosophical shift on antitrust approach. And thus far, and certainly as it comes to big tech, it doesn't seem to have materialized. And I could, go into that Mark Mador commentary on the Chicago School. But specific to the remedies in the two Google cases, what are the differences between your team's approach and Gail Slater and her team's approach? I noticed some minor changes in the remedies around AI, but was there something I was missing in there?
No, I think for the most part, there's a great degree of continuity. That doesn't surprise me. I think as you observed, the antitrust landscape has shifted, and it's one where whether it's Republican or Democrat, conservative, liberal, progressive, or otherwise, there's the sense that corporate power, monopoly power, tech power is dangerous not just to our pocketbooks and our bank accounts, but dangerous to our way of life. And while business can result in lots of great innovations and benefits to society, if business becomes too powerful and there are no appropriate checks, then that power can end up having the concentration of power. Corporate power can be as dangerous, if not more dangerous, than the concentration and abuse of government power.
Completely agree. Are you familiar with the speech and the piece that Mark Mador had written about the Chicago School and Bork? And do you have some thoughts on that?
Sure. Ask away.
Well, I think just overall, to me, it seemed like an inch away from a complete repudiation of the Bork philosophy. And I mean, is that how you're reading it?
Well, I'll let Mark speak for himself. He's extraordinarily capable and smart. And so I guess what I will say, yeah, you should. He's great. I think what I think is that philosophy has proven to be largely wrong and misguided. It's very formalistic and in many instances out of date, lacks sophistication, right? A lot of the, Chicago schoolers based on very simple assumptions about how markets function. And even assuming arguendo, and I don't necessarily agree that those assumptions were right then, they're certainly not right now. And, the way markets function today is so different. And so assumptions about rational consumers and the way businesses vertically integrate to become more efficient in manufacturing, I mean, those ideas and markets are outdated, and it would be irresponsible for us as enforcers not to update our focus. It also, ironically, it was a foundation of economics, but not enough forensics, not enough actual analysis of how markets really function. And part of what we tried to do is start with market realities. And if you talk to even the most sophisticated and successful economists today, the newer ones, most of them are focused on empirics, less of the theoretical kind of pie in the sky work, but really trying to untangle how things function. And I think that's the approach we took at DOJ, and I think that's the right way to do it.
Agreed. I think what really struck me politically is that type of statement might make it more difficult to go back, to the olden days of the last 50 years in terms of how antitrust law was viewed. And so for me, that seemed like a pretty significant shift.
Yes. And it's one that is not partisan. There might be differences of opinion, but it's not about whether you wear a red shirt or a blue shirt. I think it's a function of, do you believe that the marketplace as we confront it today is dramatically different than the marketplace we confronted in the 1970s, and the way in which businesses react to consumers and suppliers and the way in which they exercise power in the economy is different today than it was in the 70s. And whether some of those theories, again, like the quote unquote rational consumer and some of the assumptions that were baked into the Chicago School philosophies, I think we owe it to ourselves to examine whether they played out in reality. And if the answer to that is no, then we shouldn't double down on bad ideas.
Completely agree. So my next question is a little bit more philosophical with respect to the digital media space. So for most of the last 20 years, it strikes me that regulators across the globe have often pushed the gatekeepers of certain marketplaces. And forgive the term gatekeeper, because I don't mean this just from an EU gatekeeper perspective. But regulators have pushed gatekeepers to more effectively police their marketplaces when it comes to privacy and consumer protection. And more recently, it seems like things have evolved where competition law is starting to recognize there might be a downside to deputizing gatekeepers with so much power. So I'd love your reaction to that and your thoughts on, because I think it's a pretty significant shift, not just within the broader market, but potentially within the digital media space.
Yeah, it's an interesting question, and I think there are a few different approaches to it. One is, the concept of the benevolent monopolist, which is let's put somebody in control and then rely on them to do the right thing. And I think what we should rely on is that for-profit companies that are trying to maximize valuation and shareholder value are going to behave as they should, frankly, in the best interest of their business, the best interest of their shareholders. And they're going to make decisions accordingly. And even if they want to ultimately do the best thing for society, they have fiduciary obligations and shareholder obligations to maximize profits, so long as they're operating within the constraints of the law. And so even the best intentioned big company is going to operate itself in the best interest of that company. And so what do you do about that? Well, you can regulate it and say, okay, you're going to operate within the best interest of your company, but we want to impose regulations. There's a school of thought, and I've heard this directly from some folks, that we're better off having a smaller number of really big companies and regulate them because it's easier to regulate a smaller number of big companies. I don't subscribe to that point of view. Or there's another view, which is, okay, we recognize that companies are going to behave in the best interest of shareholders. So let's, as a line of first defense, make sure that markets are competitive so that they are being pushed to share as many of those benefits with society in order to stay on top or to be successful. And then over time, if there are market failures or things that are beyond the reach of competition, then you can focus on, surgical regulation or other kinds of rules or laws to make sure that companies are behaving properly. But the idea that, we simply are going to say please, and a company that has a fiduciary obligation to its shareholders is going to say, okay, we'll sacrifice our value or value to our shareholders or profits in order to make you happy, person from the government, I just don't think that's realistic. And frankly, it's naive.
Yeah, that was the philosophy, I don't want to say of all, but many of the privacy advocates. There was a strategy going back 10, 15 years ago, which is like, listen, let me just remove all of these tiny companies who are bothering us off the field, and then I can focus all my attention on a handful of larger companies. The problem is, as that's sort of played out, is like, once there are only 5 to 7 companies left that are meaningful within a marketplace, they're even less likely to listen to you.
Well, yeah, I mean, and then they end up having a tremendous amount of power, and then it makes it really difficult to impose rules or regulations because they have outsized lobbying influence, and you can sort of see that kind of run. I mean, there's no perfect solution here. I mean, I ultimately believe, and it's why I'm in the business I'm in, that a free market economy is great when it works, and so it needs competition to work, and so let's start there and solve as many of our problems as we can using the marketplace, a competitive, thriving marketplace. And then if we need to impose rules or regulations on top of that for safety and security and other needs, including market failures, we can do so. I also believe, though, there are lines on the road, stop signs and traffic lights are good. And so, yes, it's true, when you drive on the road, you can't drive everywhere you want to drive. You have to drive on one side of the road, not the other, and you have to stop so that somebody else can go. That's not bad for business, though. That's actually good for business because it allows people to get to and from where they want to be. And I think in the context of technology, we would all benefit from some lines on the road, some stop signs, and some traffic lights, not so that we can keep people from going to and from their destinations, but so that everyone can get there safely, or at least in a way that's safer than it is today.
Completely agree. And as somebody who's been pretty heavily involved in the advertising self-regulatory movements, on some level, we're all cheering because the rule set that the bar is low. But over time, that's actually not been our friend, at least the small to mid-sized VC funded companies, because however much that we may have benefited from a slightly higher rule set, the big tech companies have been benefited much, much more.
Yeah. And so that's where one of the reasons we are where we are today. And, antitrust is supposed to help keep that in check, even if it's not a panacea. And I think it failed us for too long. And that's where some of the work that we did over the last 4 years came into play.
So 2 questions that are more general to the 2 cases the DOJ is currently pursuing. The first is and I'm not looking for you to get inside their brain, but what's your take on Google's strategy when it comes to some of the proposed remedies and findings of fact? I mean, what they've been proposing strikes me as, at best, tepid. And I'm curious, just if you can place that into some historical context. I mean, is that just how this typically works? Did Microsoft do the same thing? Did IBM do the same thing? And is there a backstory here? Is this really just about not undermining their inevitable appeals?
The answer is largely yes to all of the above. So the Microsoft, AT&T, IBM cases were ultimately, for the most part, resolved through negotiation, right? And so you had, at least in varying degrees, litigation. Some won, some were settled prior to litigation or after some losses and such. But ultimately, they were largely negotiated. And so it was a matter of the parties coming to the court and saying, okay, I think we've arm wrestled and here's where we've landed. And then the court saying that's too much, it's not enough, and it needs to be changed, or it's perfect, whatever, or some variation thereof. Here we have a contested liability phase. And so, defendants in that context will often take the position, well, I'm not going to give you an inch. I'm going to make you fight for everyone. And so, yes, I lost if the court disagreed with me, and I'm just going to say, okay, I'm going to stop doing what I was doing for the last 15 years and everything's just fine. Or that even if we lost, the market has moved on, and so you don't have to worry about anything. I think that's not a surprising point of view. It's certainly something I expected, every step of the way. It's not likely in any case, in any context, to prevail. I think courts are a little smarter than that.
So I think in both the cases, the remedies proposed by DOJ refer to some flavor of technical committee to oversee Google's implementation of whatever ends up being decided. So how does that work in practice, particularly with a company like Google, who really seems to be particularly adept in running everyone around in circles? I mean, if you look at what's happened between Google and the Competition and Markets Authority in the UK with respect to third-party cookie deprecation, they seem really, really good at running people around in circles. So how does DOJ build a better mousetrap?
Yeah, they are. So the technical committee was an innovation in the US v. Microsoft case. And it ended up being, and I had some direct experience with this, a pretty substantial organization that effectively, let's say it operated as the regulator for Microsoft. But it was this group of people, engineers, who really had in-depth knowledge, and it was their job to make sure that Microsoft was complying with the decree. And when questions inevitably came up about new products and services and code, it was just more attuned to, adept, and proficient in its ability to untangle the questions and concerns. Ironically, during the Microsoft consent decree, Google would often approach the technical committee with complaints about Microsoft. And, whatever one's view is, good, bad, or otherwise, of that structure, it was applauded by the court at the end of the Microsoft consent decree as being one of the most important innovations of that settlement, of that remedy, rather, and a good framework for the future. And so, again, I don't think there's a silver bullet. It's not perfect, but if the goal here is to figure out how to resolve questions and disputes as they come up without having to race to the court every 6 weeks, having a dedicated group of engineers, people in the industry, people who know the technology and a degree of proficiency and expertise will certainly help oversight and monitoring from the Department of Justice and state attorneys general. And it will likely lead to, as it did in the Microsoft case, the parties sitting down, getting a common understanding of what's happening under the hood, and then figuring out a path forward and trying to resolve as many of those new issues before having to go to the court. Because if you do that too often, the court gets annoyed and somebody gets yelled at, and the results are probably less favorable.
That makes sense. So you have a fair amount of confidence that a technical committee is going to be able to succeed where in recent past with Google, others maybe have been less successful?
We'll see. I mean, I don't know. I think success and failure it's too binary. I think there's a continuum here, right? This is going to be a tug of war. And what you're trying to do is you're trying to reduce the knowledge deficit that will inevitably exist between the company that has a very technical product and the government that is trying to make sure that the company is complying with the law regarding its very technical product. And having somebody to help translate and get to the facts quickly, accurately, is going to make it work better. It may not be perfect. It may not achieve all of its intended results, but it's likely to be better with that structure than just having a bunch of lawyers who are well-intentioned, and even a bunch of folks who have very, very strained resources trying to keep up with, all the different coding and technical changes.
So I want to turn to the search trial. In the search case, can you quantify how important you think Chrome divestment is to the overall viability and effectiveness of the remedies? Yeah,
someone who, was there putting the remedy together, I want to be careful not to speak about anything that happened while I was there. So I'll speak in more general terms, which is, this has been discussed in court, the Chrome divestiture. The importance of Chrome to Google was something that was featured prominently in the court's opinion. And so the divestiture is, when done right, is supposed to map to the theory of liability, the theory of harm that was in the court's underlying opinion, and then the goals of the remedy, which include recurrence, depriving the fruits of violation, and in technology industry, necessarily going to be forward-looking to make sure that we're dealing with kind of where the puck is going, not where it is today. In the Google search case, Chrome was again featured prominently in the underlying opinion, and I think the remedy was crafted to map to the findings of fact and the findings of law regarding Chrome and other items. I will also say that, divestiture is cleaner. It's not perfect. It's not clean. Nothing is clean, right? But divesting or taking an open source product and making it fully open source rather than controlled, in many respects, is a cleaner, neater remedy. And ironically, it's one that the private bar has been pushing for in the context of mergers. They were upset that we weren't doing enough divestiture remedies in the context of mergers. And so there's actually a lot of familiarity with divestiture as a remedy in antitrust cases. It's just not usually used in monopolization cases because we haven't had as many monopolization cases. But historically, that's the most common or effective remedy in a monopolization case. And look back at AT&T. The remedy in the early 80s, which was done under the Reagan administration, was involving Western Electric. And in an oversimplified way, it kind of separated the hardware from the line. Perhaps without that divestiture, we'd all have rotary iPhones right now that we're renting from AT&T.
So as a private citizen, do you have thoughts on what an ideal buyer for Chrome might look like?
I'll leave that to the court. As I indicated earlier, I think it's an interesting question, and I'll just make an observation, let others decide how it should resolve. But, if you have a product that's essentially has its roots in open source, there's a question about whether those kinds of products can be handed back to the community or handed to the community to run. And, I think there's a lot of history of successful open source products. In fact, Google itself built a lot of its technology on the back of open source.
Fair. And I will tell you that the subject of potential acquirer has been heavily discussed within the ads community. And I don't know that there's a general consensus within that community. And I share that not that anybody there is an antitrust expert, but I do share it because, they're thinking through how the marketplace might evolve. And I really do think it's an example of almost least bad options because just about anybody who might want to acquire it is going to have their own motivations, which may or may not end, wind up back in antitrust court in a couple of years down the road.
Listen, you don't want to, that's where the danger always comes in. On the other hand, the status quo is one that has resulted in violations of the law. And so fixing that status quo is really important, and structural remedies are going to be more definitive. They're going to be more effective. And again, I do think it's certainly not lost on me, and perhaps shouldn't be lost on others, that the proposals revolve around open source products. And, I think it's a different dynamic and potentially more familiar in terms of, how to make that product and service available more freely and openly.
Well, and they've started to spin Chromium already out into a separate standards body. Now, I know that those two things are not necessarily directly related, but it does at least
No, I think they are related. Yeah, I mean, yes, exactly. And it's now, right, like there are a lot of the most common browsers are built on Chromium. It's just a question of who operates the kind of front end and the distribution and all of those things. And so my view is there are, to quote something that was quoted in the Microsoft remedies case, there are remedies for all things but death. And so to look hard enough.
So one of the areas that has kept many of us in the ad space up at night is the deprecation of cookies in Chrome. And so you may not be familiar with all the details, but I would imagine that that the Competition and Markets Authority in the UK and the ICO had sort of claimed cookie deprecation in Chrome as a central issue. At least that's how it, appeared from the outside. So as your team was thinking through the proposal for the divestment of Chrome, how much were the UK regulators' actions making their way into your thinking?
Yeah, I just want to be careful not to go into internal deliberations. So I'll hold off there. But let me just take a step back and make a few observations about kind of privacy and some of these concepts. I think there's a real danger that when companies get so dominant on the back of a certain kind of technology, and then, a company, for example, like Google, that has massive, first party relationships, when that, first party is defined extremely broadly, because essentially you're a conglomerate and have, you can find a first party relationship somewhere in the stack, because it creates a world where you can imagine regulatory gamesmanship where you say, okay, we're going to deprecate something but we're going to still use it, or we're going to deprecate it and then it's going to cement our power. And so I think if you look at privacy and competition as two completely distinct exercises, you can make mistakes on both sides. And so I think while we should focus on good solutions that protect privacy of users, we need to make sure that we're not entrenching monopolies in the process of doing that, which inevitably will lead to, privacy not being any better. I mean, at least in tech, the most dominant companies tend to be among the most invasive in terms of privacy. And so I think just sort of locking that status quo in is not desirable.
Different people will have different things that they hearken back to from 10, 15 years ago. For me, the big one wasn't necessarily the purchase of DoubleClick, but the big one was, I think, in 2011 when Google had announced they were combining all of their data into one big pot, because that's when I knew that the rest of us were in real trouble.
Yeah, and then there were some additional changes to terms and conditions, like in, I think, 2016-ish timeframe. And so, yeah, I mean, this kind of goes to the question you're asking earlier about kind of the self-regulatory nature, right? Like, people bought into these ecosystems with one expectation about how the data is going to be used. And then that changed. And it changed after a moment when, the world was dependent on those technologies. And so, are you going to sit there in 2016 or whatever it might be and say, I'm going to reject the terms and conditions and stop using my Gmail? The dependencies were so great by that point that, you almost had this sort of unilateral ability to change terms and conditions. And for the most part, most people don't read them anyway. And so, I think, again, this is one area where, the kind of moving goalposts, can be a problem. And also, frankly, the lack of, lines on the road and stop signs can be a problem too.
So I'm hopeful you can comment on this, because a lot of this, I think, is in the public record. But when it comes to providing access and data to competitors as part of the remedies, I thought DOJ did a great job, and you went to some pretty significant lengths to demonstrate how Google has used privacy as a bit of a red herring in order to avoid providing data in other contexts. I think there was like a half day, it seemed like it was dedicated to some things around the EU DMA and I think Microsoft's request for data and how little came out of it. And so I'm just curious how you as a private citizen are thinking about these types of access and data remedies and their relative effects. And I don't know if that's the same answer as the technical committee answer, but I'd just love to get your insight.
Yeah. I mean, listen, the questions are always very nuanced and you have to think about them thoughtfully, and how they get implemented in any one context, will differ from the other. And so I'm not sure I have a ton to add beyond what's in the public record, other than to say that if the information is so dangerous, then maybe the dominant firm shouldn't be using it in the first place.
Fair point. So one area that hasn't gotten as much attention was the imposition of rules around indexing. So the idea that, and I think this is also in the proposed search remedies, the idea that you can't collect data as part of your search engine and then use that for something different. For example, an AI engine. And I was just curious, was that in your original remedies, or is that something Gale Slater added?
No, that was in our remedies.
What was your thinking there?
Again, I'll defer to the documents there because I don't want to go into internal deliberations, but I think it's hopefully self-evident, which is on a few different fronts. One is the next inflection point that has the opportunity to unseat the search monopoly will likely come from companies that are adjacent to search in AI. And so even if those companies are not direct competitors today, they're building the ingredients and are likely to move into that direction. Similarly, when a dominant company is under most threat at a time of an inflection point, and often we see the greatest use of anti-competitive behavior, including tying, bundling, leveraging, exclusion, what have you, when firms feel threatened by an inflection point that might disintermediate the dominant player or provide openings for new technologies to change the paradigm. And so when you're designing remedies, you want to maximize the opportunity for those inflection points to have their full competitive effect, whatever that might be, right? Because part of the beauty of competition is, and especially in technology, is it could lead to unexpected outcomes. The other is to, if you're trying to develop a forward-looking remedy, see if there are ways to accelerate that timeline. And acceleration could flow from data sharing and other kinds of remedies that might, help create an on-ramp for some of those natural competitive forces to make decisions to enter faster, enter at all, and really compete more aggressively. And so, I think back to a lot of the inflection points in technology, but the Microsoft remedy came right at the time that the internet or broadband internet was, about to have its heyday, right? And Google grew up in browsers on Windows machines. And then the next technologies grew up inside of search results coming from Google. And, you can sort of take that forward. And so one platform often leads to the next. And I think you want that natural, healthy cycle of innovation to occur. And you want to keep the dominant firm from imposing obstacles, or if you need a forward-looking remedy, again, trying to provide avenues that are safe and effective. And so I think it would be massive missed opportunity, one, to allow a dominant firm like Google to prevent potential competitors who are coming in through this new avenue of AI to compete. And two, it would be a missed opportunity from a forward-looking perspective not to try to at least see if there are ways to help accelerate or invite those competitive forces in a manner that is consistent with the theory of liability, the case, and the law.
So it's interesting. I feel like you and I are reaching the same place, but coming at it from very different angles. From my perspective, and not disagreeing with anything you just said, from my perspective, there's a concept in privacy circles where there's a thing called a secondary use of data. If you provide a notice that you can use data for A and then you use it for B, that's generally considered impolite, if not illegal in some contexts. From my perspective, what I loved about that remedy, or that proposed remedy, was that you created a foothold, not just for Google, but potentially for others, because there's a huge marketplace problem right now with respect to many of the AI companies where they're collecting data for one purpose and using it for a different purpose. And I think that just in terms of overall marketplace health, I'm encouraged and hopeful that that moves from, just something that's in a DOJ proposal to something that is generally accepted as, acceptable behavior.
Yeah. I mean, like the amount of power that, again, an inflection point from, let's say, a perspective of a publisher who may want to say, okay, I may not be able to, 15, 20 years in, I may have no choice but to play ball with Google search crawlers, but damn, I don't want to be in this situation again. And so if they're going to use my data to train their algorithms or their AI or power AI generated stuff that's on the back of search, I want a choice, and I want to either get compensated or I want to, pick somebody else to work with and let competition play out. And I think we, as antitrust proponents, we want that competitive process to flourish rather than sort of letting the incumbent win simply because you can't say no to the dominant distribution channel, and therefore you're stuck saying yes to letting them these secondary uses.
That was a great conversation. I couldn't resist the temptation to talk a bit about music. Overall, I was struck by how holistic Jonathan's view of the media space is. It would be very easy for him to say that he was just operating a law enforcement agency and limit his remarks to antitrust. But Jonathan went very comfortably into the history of digital media space and privacy issues and how historically regulators may have helped facilitate the creation of some of the leviathans of big tech. Also, in my view, Jonathan struck me as being keenly aware of how important Chrome divestiture is to the future of the digital media marketplace. And finally, I'll note that Jonathan seems to have much more confidence than I do that a technical committee will be able to ensure that Google honors whatever remedies are imposed. Look out for part 2 of my interview, which focuses mostly on the remedies being proposed in the Google ad tech case. Please subscribe to the show at monopolyreportpod.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.
Thank you for listening to the Marketecture Podcast. New episodes come out every Friday, and an insightful vendor interview is published each Monday. You can subscribe to our library of hundreds of executive interviews at marketecture.tv. You can also sign up for free for our weekly newsletter with my original strategic insights on the week's news at news.marketecture.tv. And if you're feeling social, we operate a vibrant Slack community that you can apply to join at adtechgod.com.